name's Huda Hakim.
And I'm Kanama.
And we will be discussing Fisher versus Brooker and on music. So the facts are, in the case of Fisher versus Brooker 2009, the former organist in the band Pro-Coal Playroom, Matthew Fisher, brought a claim against his former band members for declaration that he had joint authorship and ownership of copyright in the song A White Shade of Pale, for which he had composed the organ solo. The defendant, Gary Brooker, was the band's singer and pianist. The second defendant claimed to be the assignee of the rights of Essex Music Limited, under the group's publishing and recording contracts. The claim was brought after a 40-year delay after the record was released. Fisher had also claimed a share of royalties. The High Court upheld the claim in 2006. The judge stated that in the absence of defendants being able to establish any detriment arising from the claimant's delay in asserting his rights, the estoppel argument must fail. Mr. Fisher's contribution to the work was not only confined to the organ solo and the small amendments to the bass line of the 8th bar of the solo. Indeed, the organ is heard throughout the 4 minutes of the work. It accompanies the vocal parts, the two verses and the chorus, but in a subsidiary role. In 2005, Brooker and Onward's implied license to exploit the song, which was revoked by Fisher. In 2006, the Court of Appeal recognized Fisher as a co-author and joint ownership of musical copyright, but held that he was not entitled to financial relief or to revoke the implied license, as there had been an inexcusable delay, 40 years, in asserting his rights. In May 1967, Pro-Coal Playroom included Fisher, which was also entered into agreement with Essex Limited. Later on, the license moved from Essex Limited to Onward Music.
The judge, on May 30, 2009, the judge, Brian Fisher's contribution was quite significant, and he made a conclusion that Fisher was the joint ownership of the musical work, and he gave a 40% contribution of share to Fisher.
So the Black Letter Law, the CDPA in 1988, showed that A White Shade of Pale is protected under Section 3(1) of the Musical Works. For Fisher versus Brooker, Section 10A, the joint authorship, it arises where there is more than one person collaborating in the execution of a work. For example, formulating the expression and the contribution are indistinguishable in the final work. This shows the likes of Fisher versus Brooker, as not only was Fisher confined to the organ solo, but also between the whole 4 minutes of the song. Accordingly, Fisher was joint author of the work. The judge, Blackburn, held that the organ solo was sufficiently different from what Mr. Brooker had composed on the piano to qualify, and by a wide margin, as an original contribution to the work. Joint ownership requires the author to have made significant contribution, to which Fisher had already done, because it wasn't just confined to the a minute of the organ solo, but also throughout the whole song. So, however, joint ownership is not respective contributions to be made in equal proportions. It also does require the contribution to be made of a right kind.
Okay, in implication of this case resolved around 3 main matters, which is the implied assignment issue, the contractual issue, and the equitable doctrine, estoppel, laches, and acquiescence. The relation of the main 2 first issue, which is the implied assignment and the contractual, the record contract issue, or that the judge had to observe if the factual term was present. And when they co-examined the case, they found out that some of the implied term wasn't really present, and the judge actually rejected that as an argument because it wasn't sufficient enough to copyright work, to the relation of copyright work. So we looked at what the judge had to observe in terms of making this decision, and he looked at the passage of time. He had to find out in which principle Fisher could claim any share of the copyright. Sorry, I don't have my glasses are broke, so forgive me for that. the free assignment implied to Fisher to lose his interest into the copyright musical work. He has to look at if this was the result of estoppel, lashes and acquiescence, and he also had to see if Fisher has the right to claim royalty, and if it was fair for Fisher to revoke the claim of Onward Limited.
So the cases that have been cited in Fisher versus Brooker is Shaw and Applegate. So there was a covenant, so in the case of Shaw versus Applegate 2001, it was taken that there was a delay of 3 years to actually put the case forward. So there was a covenant against the use of property as an amusement arcade. Within 3 years, the purchaser had installed amusement machines, but it was not until 3 years later that the plaintiff had issued proceedings and injunction for damages. The plaintiff appealed that a decision had been lost the ability to enforce the covenant through delay. So it showed from Shaw and Applegate that because of the 3-year delay, it was not enough to actually give the court further time to actually discuss and put the case into proceeding. In the case of Gillette versus Holt, it was actually a very interesting case. It was a case where Mr. Gillette left school at 15 years old, and he went to work on a farm with Mr. Holt. And Mr. Holt had then said that if you continue working for me, you don't go to school, you don't do this and that, and I will give you a share of this farm. And then a few years later, after he made no attempt to go back to school or education or anything, he was fired by Mr. Holt. And then Mr. Holt said, I'm taking you out of my will, I don't want you to be part of this farm or anything else. And that was held that the appeal was allowed. Mr. Gillette was entitled to freehold of the farmhouse and 100% to compensate the exclusion from the rest of the farming business. Robert Walker, it was in relation to the nature of propriety estoppel. It was said that it is important to note that the outset of doctrine of proprietary estoppel cannot be treated as subdivided into 3 or 4 watertight compartments.
In conclusion, this case was quite significant because he outlined one of the main issues in the practical ways in the music industry. So one of it was that the fact that the industry had an express term and they lacking to show both interest party when they contract made. And if you had a chance to look at the case, the Baroness made a good indication over those concerns, which is the fact that Essex had highly experience, and the band member was quite young, and they were in the early 20s. So this shows how much the band rely on them. And throughout the case, they could, to look at the contractual term, they couldn't see if this was really brought in the benefit of the band members. So this is really, this case has given a significance in terms of understanding how to establish a contractual term within an agent form and a musician or band members, as you want to call it. Also, it has given a bit more harmonized in the copyright, because before in the music industry you only get copyright by either being the compositor or the lyric writer. And now being a part of a band member extended that scope to other people within the segment of the music. And also it also emphasized more essence on the originality of the work by bringing the skilled labor and judgment, so I cannot see it. That's it.
That's it. Thank you very much.
Okay, questions from the audience?
No, other.
Go on, huh? No, you sure? Could I look at the next slide? Is there a next slide?
No, all the references.
Yeah.
Looks legit.
Hmm?
Looks legit.
It is legit. Thanks.
Okay, next slide.
Oops.
Okay, go from the first slide, let's have a look.
It was really good. I mean, you have to admit.
Okay, next slide.
Well, we have an opinion, isn't it?
Next. Next. So can you explain the last point, equitable doctrines of estoppel, lashes and acquiescence? Again, because that was very clear from the precedents that you were trying to explain, the three precedents that you explained.
Estoppel lashes acquaintance has to do with the duration period and the fact that the only way I can explain is by giving the example of Fisher, the fact that it took many years to bring this claim. So they had to find if it was quite fair to make a trial. So that's the doctrine that the judge had to look at. So it's either estoppel and lashes will work together, and acquiescence might not be relevant or relevant in that case.
Okay, so the three cases that you were explaining after this slide, what I understood from the three cases are that it's going against, or the decision of those cases was not in keeping with how the judge acted in this Fisher versus Brooker. Because in the three cases that you have cited after this slide, correct me if I'm wrong, there you mentioned that in all the three cases, the defendants were not able to bring, the plaintiffs were not able to bring the case into the courts because of this limitation, because of the estoppel, the time period, wasn't it?
Yeah.
Isn't
It was
it?
3 years, but then that's what they used that case as an example. I don't like they used that case as an example, but they still took on the case even though it was 40 years too late.
Yeah.
40 years
But that was
later.
the
38
defendant's side. That was the argument of the defendant.
38.
To
The
bring,
way
Okay.
Okay, so then how is the plaintiff arguing? What did the plaintiff argue?
the
And how
plaintiff,
did they support their argument?
the plaintiff didn't really argue much when you look at it for the case. He didn't really say much about it. So the judge made the decision based on the fact that, it's about the copyright of the work. And everybody has, in respect of that, right to property. So the duration didn't have much to do into it.
But isn't there a statute of limitation, irrespective of whether it's a copyright case or an IP case or a civil law case? There is a statute of limitation in every country, including the UK, after a point in which you cannot bring a case to court. So do you know what is the statute of limitation, how much time lag is allowed, and whether this decision was in keeping with the statute of limitation?
But it was 40 years.
No, that was the facts of this particular case. But generally, what does the statute of limitation say in terms of all civil cases where copyright or IP is a civil matter?
I believe 38 years.
38 years, okay. Let me write this down. Okay, let's go to the next one. Oops. Next one. Next. Okay, now here I want to ask you point by point. So in terms of originality, where is this case making a dent, or why is this case at all important in terms of the question of originality?
Because it was in relation of the implied term, that the implied assignment was granted to SX. So for the originality, is in terms of creator, you don't get any more access in that originality of work, because they gave that right to SX. So this case has both certain significance to it, because he was able to claim that back as well.
So you are saying that because the copyright rights in the final recording were assigned to the recording company, SX, obviously the fight is about whether he was a co-author 40 years later. And in order to prove co-authorship, you will have to go back to the question of originality. Yes?
Yes.
So that's what I'm asking. On the question of originality, what was he, why was he arguing, not why, but what was he arguing that he is, what is the addition, his addition to the recording, final recording, which satisfies the sweat of the brow or AOIC test, and how did the court interpret it?
They had to actually replay to prove that the organ was an important part. So the pianist did the part of the organ with the piano, which sounded completely different. So the judge made it clear that Fisher was an important part. So it made him as a co-author for that instance.
Okay. So the next question, which you should have highlighted, I feel, is that the organ part is considered to be significant by the judges.
Mm-hmm.
So who is Fisher? What is his role? As in, if he is performing the organ, what is he?
He's a co-compositor.
Is he a
co-author?
Co-author in sense of composition of the music or the performance?
He's co-author in terms of
He's
performing.
distinct.
Hmm?
He's distinct from the others, other performers.
Yeah, because this is true. It's a point that we shall clear out, because that's where the significant part of this case came, because he was a performer.
Exactly, that's what I want to know, which is not clear from the slides or from the presentation, is that if he is the performer and his contribution lies in the performance, why is this case important? The case is important because you are giving a right to a performer who, in the traditional setup of a music industry, performers are not considered important.
Yeah.
It's only the composers of music or the lyrics which go with the music, they are considered important, isn't it?
Yeah.
My last question is that overall, you are saying that, okay, the case, you are arguing that the case is an important case. It's making a dent into many things which the music industry or such industries do not take into account. But in the overall analysis of the case as a whole, did it actually make any progress vis-a-vis the rights of performers, turning upside down the hierarchy in the music industry, understanding how much royalty is to be given, when to imply license or an assignment, when not to? So on all those,
it
issues,
actually brought more structure to the industry, because before, what Essex did, they were not clear enough to the band members to know what part of royalty they will get. Now this case gives that understanding to each party when they come into a contract, that royalty will have that much significance if you bring that much skill, labor, judgment to it.
Especially because he got 40% of the royalties, so it's not half-half. So they took into consideration that how much is it, how significant is it from the song.
So, but the interesting part is, if they say that the organ solo is the distinguishing part of the song and hence his contribution is significant, but they're still giving him 40% royalty. So you see, there is
because it takes into account the lyrics of the song, the pianist, also the person who's singing it. So it takes into account a lot of factors, and that's why they gave him not 50%.
I try to understand if you can repeat the question, because
So my question is, on one hand, the court is saying, okay, even though you're a performer, your performance of the organ solo, for us, satisfies the originality test, however you conceive, however you define or understand it. But irrespective of that, we think that your contribution, this significant contribution will only lead you to 40% of the royalties. So on one hand they say you're important, but on the other hand they are not still giving him at least an equal share. So how in the music industry,
because you don't have to forget that in order to explode the song, you need a middleman between, and that's where the Essex Limited are quite important, you know, in order to gain that economic profit from it. So giving 40% share, to my opinion, is quite fair, because he just brought the song to life. In order to spread the song around, you need more skill, you need more judgment, you need more labor. So those criteria will go to the agent in place, will be the Essex Limited or Limited now. So to this extent, that's the only way I could.
okay. What about this issue of implying a license or an assignment? What was any change made in this, or did the decision change the precedents where you are just right, left and center implying assignments or license just for business efficacy?
I mean, the only, on the ethical aspect, they only emphasized the point that it will be better if the fact will be clear. Yeah, but it hasn't really changed much on the relation of what the black letter law said in terms of implied assignment. So, because if you imply assignment, you in a way you give up your right.
But here there was no clear cut, the facts were not clear as to whether he had implied a license or an assignment, either or, because he was never asked.
No, it wasn't.
Yes. So in that sense, would you agree with what I'm saying, that the court did not chart a way forward in terms of clarifying implying of licenses and assignments?
They haven't clarified that. No, it was quite. It was what the court really focused. It was the point of copyright work. So there was more focus on the fact that, you know, that at the foundation of the song, that copyright should have been given first to the band members. But the way the practice of Essex went, and this is where my understanding came, the way Essex Limited practiced their power over the band member was a bit wrong, because they should have done that prior to start the work. They came into contract when they actually started to record the song. So, like any of us will go to work, and the relation between employer and employee prior to start your work, you will sign a contract, so you're aware of what are the company policies and how you need to conduct yourself in the environment of work. So it wasn't fair enough for the members. It sounded like it was a bit of a manipulation towards from Essex to gain benefit.
But that's how the music industry generally works. The problem is, that is the inherent problem of that setup.
Yeah.
I said that was my last question. One more question. Have you found recent cases where they have used Fisher and Brooker as a precedent? Have recent cases arisen where they have used this as a precedent and it has been upheld?
It has been. I haven't got it, but I know it's been used in the state. But I didn't look at the cases for that. But I know it's been taken as consideration in the UK, and that's another reason why this case has been significant, because as we know, the United States is a big market, is the largest market in the music industry. So for a case that started from the UK to be brought back in America, it's quite important.
Yeah, but in America, this decision can only influence, it will not be directly applicable.
Yeah, they cannot influence, but it's still is still important as the influence that this case has been made in the international level.
Okay, any other questions from anyone?
Thank you so much,
Okay,
guys, for
thanks.
listening. We appreciate it. We love you all.